May 27, 2026 brought no parliamentary debate, no legal challenge, and no counteroffer from anyone connected to the Sussexes. What it brought was an announcement from the Crown Estate, a statutory body created and governed by the Crown Estate Act of 1961, confirming that every renovation Harry and Meghan undertook at Frogmore Cottage would be reversed, from the tiles on the floors to the structural changes that turned 5 employee dwellings into a single-family home, all of it funded during a conversion that cost £2.4 million. The briefing language used by the source, speaking to the press, was not chosen carelessly. Multiple outlets, including The Sun and Page 6, reported the same phrase on May 27th and 28th. The plan was to get rid of any trace, not to redecorate, not to modernize, but to remove the evidence of Sussex occupancy from the walls and floors of a house sitting on the Windsor estate and subdivide it back into the staff accommodation it once was. Harry's attendance at the Invictus Games in Birmingham falls on July 10, 2026, which placed the Crown Estate's announcement exactly 6 weeks before his closest approach to a UK return in years. And statutory bodies do not brief the national press accidentally. Institutions communicate through decisions rather than statements. And this decision arrived timed with a precision that required no conspiracy to explain, only an understanding of how these organizations operate. The pattern behind it is already established. Back in November 2025, King Charles used letters patent, the same legal instrument deployed during the abdication crisis, to strip Prince Andrew of his working royal status, and the entire process ran from internal decision to London Gazette publication in 13 days, with no parliamentary vote, no judicial review, and no window for appeal. Frogmore Cottage operates through a different instrument entirely, property management rather than royal prerogative, but the underlying logic is identical. An institutional decision executed through statutory authority, producing an outcome that no documentary or podcast can reverse, because the Crown Estate does not negotiate with press releases. That wasn't demolition, that was a message. Stay with me. Persistent misunderstanding about what the Crown Estate actually is has allowed it to operate for decades with far less public scrutiny than its decisions warrant, and clearing up that misunderstanding is where any honest analysis of the Frogmore situation has to begin. The Crown Estate is not royal property in any personal sense, and the monarch cannot direct it. Created under the Crown Estate Act of 1961, it manages a portfolio of land and buildings held by the Crown on behalf of the government, with revenues flowing directly to the Treasury rather than to any member of the royal family. Since 2012, 15% of those revenues, a figure raised specifically to fund Buckingham Palace renovations, up from the previous 8%, returns to the monarch as the sovereign grant. Commissioners run the organization and answer to Parliament through the Treasury Select Committee and the Public Accounts Committee, neither of which elected them. Applying that structure directly to Frogmore, the £2.4 million conversion, carried out in 2019, drew its funding from the sovereign grant, meaning public money derived from Crown Estate revenues paid for it, and Harry repaid that amount in September 2020 before the family relocated to the United States. That repayment is documented and undisputed. What it did not purchase was the property itself, because Harry and Meghan never held title to Frogmore Cottage. They occupied it under a license from the Crown, and that license was revoked in 2023 when they were asked to leave. Reversing the renovations is therefore a governance decision made by commissioners about an asset in their portfolio, one they can make without consulting Harry, without approaching Parliament, and without any procedural step beyond the authority already granted by the Crown Estate Act. What Parliament can still do, through the Public Accounts Committee, is examine whether that use of authority serves the public interest, given that the property generated no revenue during 3 years of vacancy, and the reversal will require additional public spending on a building already sitting idle. That scrutiny is coming, and while it will not alter the outcome at Frogmore, it will put the cost on the permanent record. Letters patent don't require Parliament, and property management decisions under the Crown Estate Act don't either. That parallel is not coincidental. It's institutional design. For viewers who come to this channel specifically for the kind of analysis that reads the primary sources, tracks the legal instruments, and follows the governance frameworks that most royal commentary ignores entirely, subscribing now and hitting the bell is how you make sure none of this lands in the algorithm instead of your feed. What those frameworks are showing right now, across multiple simultaneous fronts, is not a family disagreement. It is a coordinated institutional withdrawal, and the Frogmore announcement is one data point inside a much larger pattern. Tom Bower's book Betrayal, published March 26, 2026 by Bonnier Books, draws on years of sourcing inside the senior royal family and describes William's orientation toward his brother not as emotional but as procedural. The word Bower's sources use is not angry. The word is finished. William, in Bower's reported framing, treats the Sussex departure as a permanent institutional fact rather than a temporary family rupture, and the mechanism of that permanence is being assembled incrementally across multiple institutions. Rather than announced from a single point, royal editor Emily Andrews, whose coverage of the palace spans 2 decades across the Daily Mail and other major outlets, has identified a consistent pattern in how William's management of the Sussex situations produces its effect. Individual institutions, the Crown Estate, the Foreign Office handling Harry's security review, the Palace communications team, each act within their own mandate, and no single one announces a coordinated policy. The cumulative signal is the point. Reading any one action in isolation produces the wrong conclusion. Reading them together produces the right one. Andrew Loney, whose access to royal documentation is among the most extensive of any British biographer, has noted in his commentary on the post-Elizabethan settlement that the institutional architecture surrounding the Sussex exit was built specifically to resist reversal. The license revocation at Frogmore in 2023 removed the last residential foothold inside the estate. The ongoing title review removes the institutional identity those commercial structures are built on. Both pressures are operating simultaneously, and the Frogmore announcement arrived in the same 6-week window as renewed public discussion of both. What makes the Crown Estate's May 2026 briefing particularly telling is not that an empty property is being renovated. Vacant buildings get renovated, and there is nothing unusual about that, but that the institution chose language for that briefing that no property manager would use to describe a redecoration. Getting rid of any trace is not a facilities management phrase. It is the language of deliberate erasure, and it was briefed to journalists with attribution, placed into headlines, and timed to land 6 weeks before Harry's planned return. When an institution's representatives tell the press, the plan is to get rid of any trace, that's not a leak. That's a warning shot. The machinery is already moving. What the mainstream coverage of the Frogmore story is consistently failing to map is the commercial dimension, which matters far beyond the property's physical walls and is where the institutional erasure does its most lasting work. Frogmore Cottage functioned not simply as a residence, but as an address. And in the specific commercial territory the Sussex brand occupies, an address carries weight that extends well past its postcode. Harry and Meghan's association with Frogmore, with the Windsor estate, with a physical presence inside the geography of the British royal family's home, formed part of the credential architecture underpinning everything they built commercially after leaving the institution. The Netflix documentary series used that geography as visual evidence of their royal life. The memoir Spare leaned on it. Speaking circuit introductions invoke the implicit geography of a royal biography, and the most legible anchor for that geography, for a couple who had departed but never been formally severed, was Frogmore Cottage. Archewell Productions, the LLC through which the Netflix deal operates, was established on the identity of the Duke and Duchess of Sussex, and press materials, corporate filings, and speaking engagement descriptions all trade on the credential of that royal life. The sentence that previously read as the Duke and Duchess of Sussex associated with the Windsor estate, now reads as the Duke and Duchess of Sussex, formerly occupying a property on the Windsor estate that has since been gutted and subdivided. Those are not the same sentence commercially, even though the titles in them are identical. Meghan's lifestyle company As Ever occupies a market where brands sell an identity before they sell a product, and the identity As Ever offers carries a specific kind of provenance that royal adjacency, even distant, contested, legally complicated royal adjacency, generates in a way nothing else can replicate. Erasing the last physical connection to the Windsor estate does not remove the ducal title, but it strips away a layer of the story that makes that title feel real to the consumers. As Ever is reaching every piece of Sussex commercial content that uses Frogmore as a backdrop. The nursery footage, the garden scenes, the imagery of a home they made inside the royal estate now exists in a context the Crown Estate has permanently rewritten. Not abandoned, which implies a choice. Stripped, which implies an institutional judgment. The verb the source used was get rid of. And that verb is now the caption on every image they ever released from that address. No lifestyle brand recovers easily from the official erasure of the physical location its founding story was built around, and no PR campaign reverses a government gazette notice. Buried inside the Crown Estate's decision to restore Frogmore to its pre-2019 configuration is a constitutional paradox that the coverage has not addressed clearly, and understanding it is necessary for grasping what comes next. The original conversion of Frogmore Cottage from 5 employee units into a single-family home drew its justification from the Sussexes' status as a working royal unit that the Crown had an institutional interest in housing appropriately, and the sovereign grant funded it on exactly that basis. Public money covered the cost because the Crown considered the expenditure to be maintenance of a royal residence for a working royal family, not a speculative improvement or a personal gift. Harry's repayment of the £2.4 million in September 2020 is documented and undisputed, but the nature of that repayment has always been mischaracterized in the coverage. The money purchased financial independence from the sovereign grant, not ownership of the property. The license to occupy Frogmore remained a Crown license, the land remained Crown Estate land, and when that license was revoked in 2023, the Sussexes vacated without legal recourse, because they had none. Now, the Crown Estate is committing additional public funds to reverse the renovation that public money originally justified, and the Public Accounts Committee is preparing to examine whether Crown Estate capital spending decisions serve the public interest, with Frogmore presenting as an obvious case study. The question the committee will eventually ask is one that no Crown Estate spokesperson has yet answered on the public record. What justification exists for spending public money to ensure no physical trace of a specific family's occupancy survives in a building that generated no revenue for 3 years? The Crown Estate's answer will describe property management efficiency, pointing to the building's better function as multiple units than as a single-family home for estate employees. That answer may be true, but if it is true, the follow-up is unavoidable. Why was that not the decision in 2019? And what changed between 2019 and 2026, other than the people who used to live there? In the family and outside this institution, but now outside the walls as well, with the last physical trace scheduled for removal. Constitutional purgatory made literal in bathroom tile. California operates one of the most sophisticated legal frameworks in the world for protecting private individuals from institutional overreach, and Meghan's legal team has put it to effective use. The state's anti-SLAP statute is genuinely powerful. The consumer protection framework is solid, and privacy protections there rank among the strongest available in American law. None of that is decorative. Those are real instruments that have produced real results, including summary dismissal of the Samantha Markle defamation action. None of them has any application to the Crown Estate Act of 1961 because the Crown Estate Commissioners are not a California corporation, carry no California obligations, and cannot be brought before any American court at any level for decisions made about British property under British statute on British soil. The jurisdiction question is not close. American courts have no authority over a British statutory body exercising functions granted by British legislation, and the Supreme Court of the United States is not an exception to that principle. British judicial review represents a theoretical avenue, but a narrow one. Judicial review is available where a statutory body acts outside its legal powers, fails to follow required procedure, or reaches a decision so unreasonable that no rational decision-maker could have arrived at it. Renovating a vacant property the Crown Estate manages falls within their mandate by any reasonable interpretation of the Crown Estate Act, and a court asked to examine that decision would almost certainly find the commissioners acting well within their authority. The anti-SLAPP shield specifically protects against strategic litigation, and what the Crown Estate is doing is not litigation, it is renovation. Meghan's legal team has built a formidable structure for defending against lawsuits, and that structure simply addresses a different category of problem than a statutory body holding a building permit. The palace isn't filing a claim, it's using a hammer, a tile chisel, and a Crown Estate Act mandate. No court in California, in Britain, or anywhere else can compel the Crown Estate to preserve renovations made to a property that Harry and Meghan never owned and from which their license was revoked 3 years ago. California law protects her from being sued. It does not protect her from a statutory body with a building permit. That's not a threat. That's a mechanism. Clarity about what the Crown Estate's announcement actually means in practical terms matters here, because most coverage has treated the Frogmore reversal as a property story when it is something more durable than that. Removing the renovations Harry and Meghan undertook at Frogmore Cottage does not erase the memory of their occupancy from anyone's mind. What it removes is the physical substrate of that occupancy from the institutional record, and institutions that are simply managing a vacant property do not describe their plans to the press as getting rid of any trace. They use neutral facilities language. The choice to deploy charged language in a briefing, timed to coincide with Harry's planned UK return carries, meaning that goes beyond property management, and the willingness to absorb additional public expenditure on a revenue-generating building is itself evidence of institutional intent. Every previous crisis the Sussexes navigated had a characteristic that this one does not, a negotiating surface. The Oprah interview in 2021 was a reputational confrontation, and the institution's response, the recollections may vary statement, the controlled silence, the passage of time, constituted negotiation, even if it felt adversarial. Spare in 2023 was commercially successful and institutionally uncomfortable, and the institution's response was simply to wait for the news cycle to move, which it eventually did. The Netflix documentary used Frogmore's physical geography as visual evidence of a royal life, and that content still exists. But it now documents a location the Crown has officially erased, which changes the context permanently even though no frame of the footage changes. The bullying inquiry, the security review, the ongoing title questions, each of those processes involves a counterparty, a procedure, a potential outcome that could be influenced. The Crown Estate's renovation decision involves none of those things. No negotiating table exists. No counterparty is accepting a settlement. A statutory body acted within its mandate, and the decision is made. No documentary changes it. No podcast reverses it. No PR campaign reverses a building permit. It's done permanently. £2.4 million of public money converted Frogmore Cottage from 5 employee dwellings into a family home for the Duke and Duchess of Sussex in 2019. And Harry repaid that amount in September 2020. An as-yet unspecified additional sum of public money will now convert it back, flowing through Crown Estate revenues derived from publicly managed land, because the institution has decided that the pre-Sussex configuration of the building is what the building should return to. Most British people watching this story are not tracking letters patent or Crown Estate Act provisions, and they shouldn't need to. The sequence of events is not complicated in its broad outline. Public money funded a renovation. The renovation was risk-paid. The couple left. The house sat empty for 3 years. And now public money will undo the renovation so a property on the Windsor estate can become staff accommodation again. That sequence does not require constitutional expertise to evaluate. It requires a question: was that a sensible use of public funds? The Public Accounts Committee exists to ask exactly that, and reports indicate it is preparing scrutiny of Crown Estate property management decisions, specifically how properties are handled when they are not generating revenue, and whether capital spending decisions serve the public interest mandate the Crown Estate operates under. Frogmore presents as an obvious case study because the committee's eventual question is one that the Crown Estate will need to answer on the record. What public benefit required removing the evidence of a specific family's occupancy rather than simply moving new tenants into an already renovated building? Property management efficiency will be the Crown Estate's answer, and it may be accurate. Multiple employee units may genuinely serve the estate better than one family home. But if that is true, the question that follows is unavoidable. What changed between 2019 and 2026, other than the identity of the people who used to live there? The machinery of public accountability is the Public Accounts Committee, and the British taxpayer, who funded both the renovation and the reversal, is the person that accountability is designed to serve. Here's what we know. Not suspect. Not theorize. On May 27th and 28th, 2026, the Crown Estate briefed the press that every renovation Harry and Meghan undertook at Frogmore Cottage would be reversed, with a source using the phrase "get rid of any trace," and the property would be subdivided back into multiple employee dwellings. That announcement landed 6 weeks before Harry's planned attendance at the Invictus Games in Birmingham on July 10, 2026. The original £2.4 million renovation drew funding from the sovereign grant, public money derived from Crown Estate revenues, and Harry repaid it in September 2020. 3 years of vacancy followed after the license was revoked and the Sussexes vacated. Additional public expenditure will now fund the reversal. The Crown Estate operates as a statutory body under the Crown Estate Act of 1961, answerable to Parliament through the Public Accounts Committee, functioning independently of direct royal instruction, but within a framework of institutional coordination that Tom Bower, Emily Andrews, Andrew Loney, and other named commentators with documented sourcing have characterized as purposeful rather than coincidental. Bower's betrayal, published March 26, 2026, documents William's approach to the Sussex situation as procedural and permanent. Royal editors across multiple publications have documented the pattern of coordinated institutional withdrawal operating through separate actors, each acting within their own mandate, producing a cumulative signal no single announcement could deliver. The briefing language chosen, "get rid of any trace," is not neutral property management phrasing, and the timing against Harry's planned UK return is not accidental. This isn't a conspiracy theory dressed up with statutory law. This is institutional machinery already in motion. The precedent exists in Andrew's title removal. The mechanism has been tested and documented. The intention has been briefed by named sources to named biographers. The blueprint is being followed, and the physical last trace of the Sussex occupancy on the Windsor estate is being removed by a statutory body whose decision cannot be challenged in any court Meghan operates in. The only missing variable is what comes next. Public money built Harry and Meghan a family home at Frogmore Cottage in 2019. Harry repaid it in 2020. The house then sat empty for 3 years, generating nothing, while the couple built their commercial life in Montecito. And in May 2026, 6 weeks before Harry's first significant UK public appearance in years, the Crown Estate announced it was spending additional public money to ensure no physical trace of the Sussex family remains in that building when the next occupants arrive. The tiles are coming out. The walls are being restored. The rooms are being subdivided. The source's chosen phrase was "get rid of any trace." And that phrase is now embedded in the institutional record of how this moment was described by the people who made the decision. 6 weeks before he comes back, here is the specific question worth answering in the comments, because it matters for understanding what follows. Erasing someone's bathroom tiles is not the opening move of an institution that considers a matter closed. It is the closing move of an institution that considers the matter almost closed, and the word almost is doing a great deal of work in that sentence. If the institution is willing to spend public money, additional public money, beyond the 2.4 million already repaid, to remove the physical evidence of the Sussex occupancy from a building on the Windsor estate, what does that institution consider to still be unfinished? Tell me in the comments what you think comes next, because the machinery is moving, and Frogmore Cottage is not where it stops.